Good morning. Can everybody hear me okay? You can pop a note in the chat or give me a reaction if people can hear me okay. There we go, we've got a reaction. Right, thank you for that. So welcome to today's webinar on local authority owned companies, directors' duties and conflicts. By way of introduction, so I'm Nigel McCloy. I'm one of the directors of First North Law, which is in a really unique position to advise on local authority owned companies, particularly the directors' duties and conflicts, because First North Law is a wholly owned local authority company, and I am one of those directors who on a daily basis faces the inevitable tension between my duties as an officer of the authority and a director of First North Law. So this webinar is being presented as part and run as part of the YPO Legal Services Framework, of which First North Law are one of the 6 panel firms. Little bits of housekeeping. There is a chat function, there is the reaction function. We'll also be running some polls today. So I've got some scenarios where I would really welcome your feedback during the presentation. There's also the opportunity via the Q&A to ask questions as we go along. Sessions in the slot for about an hour, but in reality takes about 45 minutes to present. So there is plenty of time to answer those questions, either as we go through or as we get to the back end of the session. So moving on to the agenda. There are 2 real parts to the session. The first one is the meaty part, and we'll take the vast majority of the 45 minutes to an hour today, where we'll be reviewing directors' duties. So we'll be looking at the statutory, the fiduciary and other duties applicable to directors. And as I say, working through 4 examples of real life scenarios which can arise, particularly in local authority owned companies. We then touch a little bit on conflicts at the end, and really, as you'll see, spoiler alert, conflicts are really quite unavoidable in local authority owned companies. So it's more about managing those rather than eradicating them entirely. And that's a bit of a quicker session that we'll whistle through at the end. So I can just see actually there's a couple more people joining. So for those of us that have just joined, don't worry, you've not missed anything apart from the introduction and from the agenda, because this is the first main slide. I will pause for about 60 seconds now just to see if there are anyone else that's going to come along and join, just so as they don't miss any substantive elements. Don't think anyone else has joined. 60 seconds always seems like an eternity whenever there is a void to fill. So we start with the basics of a company structure. So companies are structured where there are directors and there are shareholders. I appreciate for many of you in the call today, you might know these sort of simple aspects of a company structure, but they do get confused and often cause problems down the line where people do not understand the different roles. And so a director is responsible for the day-to-day running of a company, and they are granted power to do so by the company's constitution or the Articles of Association. And in short, the Articles of Association are the Bible by which companies should be run. They are not unique, so it's not one size fits all. They're very much a situation whereby you can set out bespoke articles for your companies, or if you wish, there is what's called model articles that you can lift off the shelf. But it's really important for directors to understand what the articles say for their company, because they do vary quite widely from company to company. The shareholder, well, the shareholder or shareholders, they own the company. So they limit their liability for any damages or any claims arising personally in their role as a shareholder by simply putting the money in at the outset and say, that is my liability. They aren't responsible for the day-to-day running of the company. They entrust that to the directors via the Articles of Association, but they are still involved in certain key decisions. So you will often see appended to Articles of Association certain reserved matters, and those set out what the shareholder must do and what the shareholder wants to do. whenever it comes to making decisions. You'll see at the bottom, they can be the same people, and often in smaller companies, sort of the element of a single individual, they will set up a company, perhaps for tax purposes, and they will be the sole director and sole shareholder. Even in those circumstances, however, it's really important to understand what hat you are wearing when making decisions. In the context of the webinar today, local authority-owned companies, there is usually a very clear distinction between the directors responsible for the day-to-day running and the shareholders. So for directors, which is the main topic of today, what are the directors' duties? Where do they come from? So, well, the main aspect of the directors' duties comes from the Companies Act 2006, which at the time it came in was one of the largest pieces of legislation. And it wasn't a really clever move on my part to start studying company law between the years of 2004 and 2007, because it meant that I had to know both the old act and the new act because I was tested on both. We'll work through sections 171 to 177 of the Companies Act 2006, which are the real key 7 duties that directors must be aware of. As I say, the other duties which are there listed on the slide, there may be some contractual duties, your common law duties, and as I say, your fiduciary duties, which include duty of confidentiality. So we'll work through. So I'm just struggling to get to the next slide. There we go. We will work through the 7 duties, section 171 to 177. These apply to all directors. So anyone that considers them to be a non-executive director, local authority officer that says, no, actually, I'm not employed by the company, therefore I don't need to worry about it. That's not the case. Legally, this applies to all directors, and you must be aware of those duties. We'll jump straight in. So to section 171. So section 171 is a very simple duty, very straightforward duty, which says that you must act within your powers. We know that the powers are granted by the Articles of Association because we covered that earlier, but you must use those powers for the purposes for which you're given and the terms of such authority. Now, that on the face of it seems quite simple, but with great power sometimes comes great responsibility. So if we move on to our first scenario, you'll see a situation here where I'm after some feedback from the audience today. So a director enters into a contract committing a company to provide services, even though the articles are clear that entering into contracts requires not just director approval, but the board of directors approval. So is the company required to provide those services? And hopefully my assistant Poppy will pop up with a poll for you to answer in a second. Cool. So I'll give some time for people to click the feedback. Does the company have to provide the services where the director has no authority to do so? See, we've had a couple of responses in there. Give it 30 seconds more, see if anyone else wants to be brave enough to answer the question. So, a couple more answers in there, and a split across the room. So we've got the vast majority of it that says yes, the company is required to provide the services, and some in the camp that says no, the company is not required to provide the services. I suspect that if we were in a more open forum, we could generate a bit of discussion about where we're both coming from, because it can be both situations. But the starting point for this scenario is if a director has entered into a contract in good faith with a third party, so that's the third party's good faith, then the company will be bound to provide those services. And that's the point that I mentioned just earlier. With great power comes great responsibility. So you're given the title of a director, somebody that is negotiating with a company is entitled to understand that that director is acting within the limits of their authority. So it's not on a third party contractor to go and read your Articles of Association, which are actually in the public domain and available in Companies House, but also it's not for them to check perhaps that you've got board approval. that third-party company is entitled to rely upon the very fact that you are a director to bind the company. There are some circumstances where it's very clear that the company wouldn't be bound. And the one that I use as an example is if you've got a local authority-owned company that's building houses and the managing director of that commits with somebody to build perhaps a 5-bed detached house for £10. Clearly, that's a situation which, on the face of it, and absolutely to anybody that's on the street, is not going to be in good faith. So the company wouldn't be bound by that. But the vast majority of circumstances where it's commercial agreements, they will be bound. They will have to provide the services. The purposes of today's session is to make sure that you understand your duties as a director, and you need to know that if you do that, you can face a sanction for knowingly exceeding your authority. So that's just a bit of an example of where you see a simple duty, but when you put it into practice, it can cause some issues. So section 172, again, many lawyers will often debate that actually this should have been 171 because it is considered to be the overriding duty. So this is the duty to promote the success of the company. Again, it applies to all directors. Now, success isn't defined by the Act. It does vary from company to company, and the vast majority of local authority-owned companies may be set up to generate a profit. That's often what they will do, but profitability does not always necessarily mean success. You can have several circumstances where a local authority is designed or is aiming to provide different services to fill a gap in the market, and they don't mind that it just breaks even. So if you've got those type of companies and you're being held to account by your members saying, where is all the money? Where is the profit? That may well be applicable and appropriate for your company. But as I say, it's not technically the definition within the Act. The duty as a director is to just simply promote the success of the company. So we'll look into what factors would we like to see when you're considering promoting success. As a director, you should really be considering what is the potential impact, particularly long-term impact of your decision. Is it going to be in the interest of employees? Many companies rely, particularly local authority-owned companies, rely upon their employees in the first instance. They are the main and sort of heartbeat of the company. So when you're making decisions, what's the impact on those? We live in a world, again, where many people will look at net zero, etc. Look at longevity of companies. Will the business be more sustainable as a result of this impact? What's going to be the impact on the environment? Will this promote our brand? And are we acting fairly? If as a director, you've gone through and you've looked at all those factors and you've come to a conclusion, often then your decision will be considered to be appropriate and promoting the success of the company. Second work example here. So you have a local authority which has a group of companies. The local authority appoints several officers, such as myself, to the board of those companies, and it has lent upon those directors saying, send funds to another company within the group because the local authority considers it benefits the group of companies. So a situation where I'm sat as a director of First North Law, I get a phone call from my shareholder that says, send money to a different company owned by the same shareholder. Do we think the directors should comply? Another poll should pop up in a minute. So we've got a couple of responses in. As I said, I'll give people a couple of minutes longer. So again, we've got a little bit of a split in there. And I may well be talking to a room full of lawyers who like to sit on their fence and say neither of the above. But we've got one certainly in the no camp. Nobody's saying yes, which is good from the first instance, because again, as a director of the company, you must promote the success of the company. So it's not a situation whereby it can be a simple yes or no answer, but certainly if there were going to be one of those, we would lean into the no camp. If your local authority is putting a request upon you as a director, you cannot simply just follow that instruction blindly. As a director, you owe the duty to the company to promote the success. So as a director, you should be going off, satisfying yourself that the transfer is in the company's best interest. Now that can occur. So this situation today is not about creating difficult directors and not about falling out with shareholders or your owner authorities on a regular basis. It's about making sure that directors properly make decisions within the legal framework. So what we'd like to see is directors go off, ask some questions, probe the instructions, and then form a view independent of that external influence on whether or not it is appropriate and in the interests of the company. Moving on to the third duty, which is the duty to exercise independent judgment. So again, this sort of goes hand in glove with the previous scenario. But as a director, your judgment must be your own. It should actually be independent of the view of the other board members. You're not simply there to parrot everybody else's decision and nod them through, and you must not fetter your discretion. You are allowed, because there may be a circumstance where there is a decision to be taken where you are not an expert in the subject field, so you can go and take expert advice. Or indeed, if the articles of association permit you, you can delegate. But even if you delegate, you have to remember that you are still responsible for the delegation. So it's not quite a get out of jail free card on that aspect. So our third example, in the context of that duty, the local authority owned company has an opportunity to win new work by providing services to an adjacent local authority. It's going to make some money, it's going to increase profitability, and no what I would call technical issues in play. A technical company is a company which it's actually old terminology, it's no longer called tackle, but you should only have 20% effectively profit margin or on there on all of your turnover. That's not in play here. We have got the situation though that a company can go and win some work, but the politicians are getting involved. So it's politically undesirable, and therefore the local authority has asked the board members appointed by it to vote against the opportunity. So in summary, company sees an opportunity, make more money, branch out their services, but the local authority is again leaning on those board members appointed to it and saying, vote against the opportunity. What should those directors do? Right, so uniform agreement. This is good. Every time I run this session, people get to the third question, and often the penny seems to have dropped, which is really good because it shows that people are understanding the situation whereby they're acting as a director. So as a director, you may have been appointed by the local authority, but that doesn't mean that you simply have to follow what they do. And indeed, that would be a breach of your duty as a director. You must consider the proposal, make your own decision free from the influence of the local authority. What that actual decision is in the end is almost an irrelevance. It's the purpose of today is to ensure that you follow the proper process. Moving on to section 174. So section 174 is the duty to exercise reasonable care, skill and diligence. So this is a two-tier test with a subjective and an objective element. So the objective element is that every single director, this is every single director that is registered in the Companies House for every single company, is expected to have the ability of a reasonably diligent person carrying out the same function. So there is a baseline standard for which you're expected to know and understand your duties as a director. So that's the baseline that's there. That means that in the event something goes wrong, as perhaps we've seen with other local authority owned companies, such as that down in Nottingham, You can't simply turn around and say, I didn't know what I couldn't understand, or I didn't know my duties, for example, because I am a local authority owned officer and I'm not familiar with the director's duties. That is not an excuse. So the situation is, as a director, there is this baseline standard, which is the objective test listed there. For those of us that have specialisms, so there is also a subjective test, and this is part of the time whenever I dislike being a director and a solicitor as well, particularly one that operates as a head of legal within North Yorkshire Council, who own First North Law, because you can be held to a higher standard where your personal knowledge and skill set means that if something again goes wrong or somebody is auditing the company, they will look to you as a director and say, Nigel, hang on a second. You're a solicitor, you've been a director of a number of companies, you've been company secretary of a number of companies. Why has this gone wrong on your watch? So you just need to be aware, those of us that have got a skill set and a unique skill set, which may be in finance, it may be in HR, it may be in, for example, housing companies or environmental companies, that personal knowledge, which is often the reason you're appointed to the board, can mean, and indeed does mean in many circumstances, you're held to a higher standard. So we're rattling through and making good time, sort of 25 minutes in. So we're on to section 175, which is the duty to avoid conflicts of interest. Now, this kind of goes hand in glove with section 177 duty, and the section 177 duty, which we come on to later on, has our final worked example. But there is a duty as a director to avoid conflicts of interest. Now, as mentioned at the beginning, the second part of this session is what do you do with conflicts of interest? Because whilst the primary duty is to avoid situations where your interests conflict, often in local authority owned companies, they are unavoidable. So the bit that's in bold there on the slide is the main part to take away from today's session in relation to conflicts of interest. If you are in any doubt whatsoever about whether you may have a conflict or whether you do have a conflict, my recommendation is disclose it. Firmly disclose it, make sure it's clear and transparent. That's both for direct and indirect conflicts. So it doesn't need to be you personally, because if you do that, it's often the case that those conflicts can be authorised. And that's great because you're covered. You're complying with your duty. You're saying, I'm avoiding them where possible. But if there's an unavoidable situation, you're declaring them. And then you get into a situation where if, again, something goes wrong, which is often whenever these companies get scrutinised in greater detail, it's a clear audit trail to make sure, again, that the company knew about that conflict and they authorised it. So again, I'll labour the point one last time. If you are in any doubt over a conflict of interest, get it disclosed, get it authorised, provided the other directors are happy to do so. Section 176, for those of us familiar with local authority owned companies, and particularly those that are officers of local authority, this one's a very simple, straightforward duty, to be honest. Duty not to accept benefits from third parties. And in effect, this is a duty to be honest. You have to remember the company's property belongs to it. It's not to you as a director or the shareholder. Key part of understanding this aspect of it is there isn't really a minimum benefit and it doesn't need to be a financial benefit. Now, I know some of you out there will be thinking, well, hold on a second, particularly in the private sector, there are huge degrees of hospitality. How does that work? But you'll see at the bottom there is, again, the constitutions, the Articles of Association for each company can set an acceptable minimum threshold. So you can have a circumstance whereby the company makes it clear what in its view is acceptable and what isn't. So again, comes back to the point that I said right at the outset for directors, make sure that you know your Articles of Association. They are your rule book, they are your Bible for your company or companies. Moving on to the last statutory duty that we've got to look at today, which is section 177. This is a duty to declare an interest in a proposed transaction or arrangement. So this is, again, very similar to the conflicts of interest, but this is where you actually have an interest in a proposed transaction or arrangement. Now, the big thing about this is if you're going to enter into a transaction or arrangement and you've got an interest in it, you must declare it beforehand. That is an absolute must. It's not something that can be remedied down the line. and you must declare to the directors the extent of any interest that you've got with the company. You'll see at the bottom there, model articles of association actually prohibit directors from voting on that transaction. But for local authority owned companies, again, where you will often have agreements and interest and transactions between the local authority and between its wholly owned company, you'll see that often that is amended, and certainly we would recommend that in several circumstances, particularly those technical companies that I mentioned earlier, because again, you have a situation whereby 80% of the work of that company is done for the local authority. So we move on to our final scenario, which is Company A wants to buy cleaning services from Company B. Can a director of Company A, who is also a director of Company B, vote in favour of entering into the contract? Oh. Just give it another sort of 30 to 60 seconds. Let people consider it in a bit more detail. So you've got a director who's on both sides of the fence. Can they vote in favour of entering into the contract? So I've got a bit of a split again. There we go. Right, I think that's all of us now have put in. So the vast majority of us are in the no camp. Some are in the yes camp. So, and the answer is yes, but only if the articles permit authorization. So it's again a situation whereby it is possible, legally permissible, provided the rule books of the company provides authorization and the interest is declared beforehand and the non-conflicted parties have authorized it. Key part here, which often directors will slip up on, is the bit in brackets. It does need to be both sides. So you've got a circumstance where often a director will recognize, I have an interest in a transaction with Company B, tell everything that it needs to know to Company A to say, I have a conflict here and I have an interest in this transaction. Can you authorize it? Get it all authorized, and they do that on one side of the fence. It does need to be on both sides of the fence. So it also needs to be declared to Company B and approved by Company B. And again, articles of association for both companies need to permit that authorization. So you'd be glad to know that that's the end of our quizzes and polls as such, and also the end of the section 171 to 177 statutory duties. So the rest of it's all very much plain sailing from here. And as I say, I think we're making reasonably good time here. So it might be between that 40 minutes rather than 45. There are other general duties that you must be aware of as a director. Often, if you stick to 171 to 177, you will not go too far wrong, but you have another declaration of interest in an existing transaction or arrangement. That's 182, sorry. You have other general duties such as filing. And for those of us that are directors, you'll be aware of that. So you've got a situation, confirmation statements need filed, accounts need filed, etc. Companies House will write to you and will chase you, and indeed will fine you if you get those wrong. You must not act whilst disqualified. So if you're in a situation where you have been disqualified, again, this is very clear and obvious, you must not act. The Bribery Act, again, is very similar to the Section 176 duty, but you must not take bribes. And your routine matters of health and safety, and of course, the very lovable GDPR, which again requires you as a director to comply with the data protection and general data protection regulation. So things to be aware of. If I went into each one of those, they would be their own sessions. And often whenever we run these, actually, we do it back to back with our health and safety colleagues who do a second session just dealing with health and safety. But for the purposes of today, if you are aware of those duties, again, you'll not go too far wrong. So what happens? I've told you all the duties. We've been to the session today. Hopefully we won't go wrong. Hopefully we won't breach the duties. But what happens if that does occur? So if a claim arises, in the first instance, the company is generally liable for them. So again, a director making a misstep, a bit like in our first scenario where it bound the company, even though the director didn't have authority to do so, you're generally burdening the company with the liability. But that is not always the case. Directors can incur personal liability where you have given a personal guarantee. So again, please ensure, top tip to take away, if you're signing contracts on behalf of a company, please ensure that it's not just your name at the end. Make it very clear that the execution clause says, your name, or in my instance, Nigel McCloy, Director of First Norfolk, and makes it clear that I'm signing in that capacity on behalf of the company. You're also, again, won't surprise many people here today, you're not covered if it's fraud or indeed wrongful trading. So wrongful trading, for those that aren't aware of it, is if you continue to trading where there's no reasonable prospect of avoiding insolvency, because in effect you're burdening the creditors, you're probably losing and hemorrhaging some more money. And again, the questions will be asked of the directors, coming back to our first sort of opening slide, who are responsible for the day-to-day running of the company. And that also includes, as I say, making decisions about can we actually trade our way out of this mess. Last two, if you act outside the scope of your duty or as a breach of them, you can potentially be personally liable. So almost a little checklist here for you to avoid breaches. So the one at the top is really the most important. Be familiar with your articles of association. Again, have them on your bedside, do a bit of bedside reading, check them over. They are your Bible for your specific company, or indeed companies if you hold more than one director title. If you're familiar with them, you again often won't breach them, which is good, but you will also assist your company in running in a compliant manner. Won't surprise you that as a solicitor sat here, I'm telling you to keep records. But again, they're really important that you've got those records, because they will be your evidence if something goes wrong that you have complied with your duty. As I say, avoid conflicts where possible. We'll talk a bit more about that in a second, but monitor your compliance. And again, appoint qualified and experienced managers, because then whenever it comes back to making your own decisions, you won't always be relying on experts. You won't always be delegating your decision making. You will be able to do a better job as a director and avoid breaches if you have the appropriate guidance and appropriate expertise. So ensure your proper reporting procedures are in place. And the last limb, which is something to consider. So consider director and officer insurance. That is something that many companies will consider to be necessary, but you have to remember it doesn't cover any kind of criminal liabilities. So if you are committing fraud or anything like that, which I'm sure none of our audience will be today, that's not going to kick in, but it is appropriate that you consider it just as a fund of last resort in the event that breaches do happen and directors need to be protected. So moving on to conflicts, and this webinar is very much about local authority owned companies. They will many of those companies will be those tackle companies. The very definition and legal test to be a tackle company is that there must be demonstrable control. That's part of the tackle test. Local authorities will demonstrate that control by appointing directors, by having articles of association that can perhaps be quite rigid and quite clear, which then means that it is unavoidable that you've got this tension between control element and the duties of a director that we've just come through. So whenever I run this session on a regular basis for tackle companies, they really want to say, how can we simply avoid these? In my view, it's impossible to avoid them. It just is a necessary evil to balance the tension between that control element and the director's duties. So it's about mitigating and managing those conflicts. Giving some examples of where you see these and where I wouldn't like to see them, but again, they can be unavoidable. If you've got a Section 151 officer who is on the board of any local authority-owned company, you can see that unavoidable tension. Often these companies will be set up by finance from the council. They will get a loan. And if I'm a Section 151 officer, how can I ensure that as from on behalf of the council, that I'm getting the best return on that loan? So if I'm setting the commercial rate, how do I know if it should be 4%, 5%, 6%, 8% above base rate? Because I want what's best for the authority. But if I'm then on the other side of the fence and I'm a director, I have to act in the best interest of the company. I have to promote the success of the company. So I don't want it to be 8%. I want it to be 2 or 3%. And you can see how that's very difficult to recognise and reconcile that tension. So in a circumstance such like that, I wouldn't like to see a Section 151 officer approving both elements of the loan, wearing both hats. So that's where a delegation we want to come in. Again, if you've got elected members, particularly as we come up to election time, you will see that there is often quite a significant element of political affiliations and political interference, which causes tension because the company is trying to continue to trade on irrespective of the political landscape. But elected members will also be aware of their code of conduct for members and indeed their need to get voted back in at the next stage. So here within North Yorkshire, so we've done a recent review with a view to removing the vast majority of directors from our company, or sorry, vast majority of members from our companies, save for where they are deemed to be essential. Again, other senior officers. So again, I don't like to see your head of paid service or your chief exec on any boards. That does happen, but again, it's very difficult at times to reconcile those decisions, and you will often see many delegations being required. And another example, I wouldn't really like to see any planning committee member or a senior officer on the board of a property development company, because if the company is set up purely for the purposes of property development, then the reality is that they also shouldn't have a finger in the pie on approving or setting planning permissions and or conditions. So our second last slide, next one I'll open up into questions. How do we manage conflicts? Comes back to the bit in bold earlier from the Section 175 duty, sorry. Declare your conflicts on every occasion. So, and if in any doubt, get it declared. We do recommend here at First North Law that you have declaration of interest forms because we consider it to be good practice. And again, it gives you that record. So it instills good practice and brings things to your to the forefront of your mind when you are making decisions, but they aren't essential. So if you don't want to do that, it's not absolutely necessary, but it is a recommendation. Make sure you imply foresight to decision making. Make sure you're wearing the correct hat. It's very easy to fall into that trap of saying, oh, I'm wearing, I'm an officer of the authority, or if you're on several boards that you're acting perhaps for company A, B, when you're making decisions for company A. So just make sure that you're switched on, wearing the correct hat, again, document it. Undertake regular refresher training, because with the best will in the world, hopefully you'll go away from today having this at the forefront of your mind, understanding the duties and applying those to the decisions that you're making. However, the day-to-day reality of getting on with the day job, again, means the lines tend to be blurred. So make sure you've got refresher training in place. Make sure that you do bring it back to the forefront of your mind, and have regard to other guidance. There is regular guidance updated, particularly from SITFA, which is fantastic. And I'd recommend everybody here go off and have a read of that SITFA guidance. There are other corporate governance codes and, as I say, different regulations listed there on that slide. So we've rattled through that in 41 minutes, which does leave us a bit of time for any questions. I'm happy to take questions either via the Q&A function, the chat, or if anybody wants to come off mute and ask them out loud, I've got no issue with that. So opening it to questions. Don't think anybody's going to be brave enough. So either that or the warm weather's got this. No, thanks, Mira. So I'll leave it open for another minute, and then, as I say, we'll close down the session. But if anybody has got any questions, or, as I say, doesn't want to be brave and ask things in this forum, which I appreciate can be intimidating, just drop us an email after it, and we're happy to pick that up. But so I think that's probably us. So thank you all for attending. It's been really useful. Thank you for participating and filling in the polls as we went along, and we will see you again soon. Thank you.